Carolyn Grawi, and I am so thankful to Belinda Doolin and Sally Brush for having the Dispute Resolution Center trainings and having chairing this committee and having me speak today. Happy New Year to everybody. I am a person with disability, so the first thing that I think of when I think of disability is what's not going to get in my way today. And so recently I was in a crosswalk though, and I was hit by a car. So I am sitting rather than standing, and you don't have a PowerPoint. I'm going to go from this outline that I've given you because I am dealing with the repercussions of that accident. So I'm sorry that if I get lost in myself today, I apologize for that, a little more than my usual. But I just am very thankful and grateful to be able to be here with you. And so when I knew I was going to be coming home anyway and resting, I thought, well, I'm going to go forward and still do this presentation today. So Sally didn't even know that there was a chance I wasn't going to do it. And I thought I didn't want to not go through with it. So that's one of the things that I guess I think all the time is determination, persistence, inclusion, opportunity, and not just opportunity, it's equal opportunity. That's really what it is. So you have some pieces of things in front of you. I'm just going to tell you what you have for a moment. In front of you, you have an outline which is about how to establish conflict mediation sessions that are an inclusive process for people with disabilities. It's just an outline of some topic areas that I'm going to go over with you. You also have, and I had one, but I don't seem to have one now, a disability awareness and etiquette page. And you also have a guidelines that was created through a work group. And even somebody from Michigan, Doug Van Epps, was part of that work group. And one of my favorite people related to the disability movement, Judy Cohen, was also involved with that work group when that was written. It was written some time ago. Between 98 and 2000, they were working on it. And there were some decisions that were made at the national level for how specific ADA cases are going to be mediated. And that's why that wasn't pursued or pushed as hard through everybody. But what I think is really important, and why even in my 40-hour training that I had with Belinda and with Sally, was that I think we have to remember that at any point in time, anybody you come in contact with may have any reason that they might need an accommodation. There could be language, there could be migraine, there could be health, there could be apparent disability, there could be age, there could be all kinds of things for why at any point in time something may come up. And so I think that it's critical that we think about this more thoroughly and more openly. There's more than 57 million people today in the United States who have disabilities. Now, those are folks who claim that they have a disability. There are many other people who have disabilities who don't choose to say they have a disability. And that's everybody's right. Everybody gets to claim or not state that they have a disability. What we want, and when I say we, people with disabilities, Centers for Independent Living, the Department of Justice wants everybody to have this equal opportunity to be involved, engaged, and participate at the level that they would like to. Now, that doesn't mean that we don't have issues, meaning people with disabilities. And when I say we, when I do that, it's because I am a person with disability and I claim my disabilities. My disabilities, just so that you know that too, let me step aside for that with my introduction for a moment, just a moment here, is that I'm a person who's legally blind, so that's why you see the cane here. If you see me walking around at night, I'm going to have this cane out and using it. Often I carry it with me so that maybe other people notice that at least it's something about me. When I was hit by the car, the cane was out. It was dark. It was reflecting in the light. I don't know why the guy didn't see me, but he said he didn't see me. So sorry. Oops. Anyway, and I also happen to be a person who has diabetes. I've had diabetes back to 1978, so I was a young person at the time. And what happened for me with that with my family is that I was a competitive swimmer at the time, and we didn't stop me swimming. I kept swimming. We figured out how that was going to happen. Now, I didn't go to the Olympics like the other person with diabetes who won gold medals, but I was able to pursue a life of other things and goals and be engaged in things that I wanted to be engaged in. And I think that because my parents had that open mind and social action and other ways that were things that were there, that kind of leads the framework of who I am. And my third disability that I talk about is that I had a traumatic brain injury back in 2000 when I was in a car and was in a severe accident. And so I now have another brain injury. How this one directly is going to keep affecting me, I don't know, but hopefully it won't. That's knock on wood. It won't change how I get to engage with the world. But those are some different pieces that are there. But the ADA, the Americans with Disability Act, was passed in 1990. If you go to ada.gov, you can find out as much as you would like to. I could have done 40 hours on disability for you, and it still wouldn't have probably scratched the surface. But what that is happening there is that people are persons with disabilities if one or more of their life daily functions is altered or has to be accommodated or that is impaired in some way, that it changes how they do things in life, and so that is a disability. If you are a person who is perceived to have had a disability, so let's say that you're a person who has now recovered from cancer, but people keep treating you as if you have a disability, then that is somebody who's covered by the ADA. And if you're a person who is caring for somebody else who has a disability and you're treated differently by your job or by your family, that also protects you with the ADA. So those are the big three that are covered under the ADA. And there are 4 titles that are most commonly known, and the 5th title that covers miscellaneous things, and we could go on and on about them. But I'll just very briefly identify the titles for you, just so you can get a framework of it. Title I is the employment title of the ADA, and that is saying that if you're employed someplace outside of Michigan, they have 15 or more persons with disability, then you have to provide accommodations to your employees. Here in Michigan, we have another law, the Michigan, I forgot the name of it, the Michigan, they changed the name, there's a Michigan Disabilities law, we'll leave it at that so I don't take our time trying to figure out the name while my brain catches up with me here. If one person, so if you own your own business and you work for it and you have a disability, you have to be accommodated. That's basically what Michigan has said at our level of policy here. So in Michigan, every single person who's working is protected under disability rights in our communities. And those kinds of accommodations can be as simple as the type of door handle, the type of table we have. It may be when you get breaks. It might be if you're allowed to have food at your desk. I remember that when I was younger, I worked at the emergency room, and I would work sometimes 16 hours instead of just an 8-hour shift. And sometimes you'd be busy, and you could not get up from your desk at the entrance of the hospital. And so you would have to have something there, or in the actual emergency bay, in the trauma bay, if they were giving orders and things were going on right and left, you couldn't go take your break. Well, as a person with diabetes, I had to be accommodated to have a snack that was always at the desk. I remember one time a doctor saw me eating, and he said, "I'm going to report you. You're not allowed to eat at the desk." I said, "Well, I am, but you can," and he did. And then he found out that I had diabetes, but I had to have it. It wasn't about a debate at that point. At that point, it was needing to be eaten, and it was there, and different than what the rule was an accommodation for me at that point. So there's all kinds of accommodations that people may have for their employment and be able to do the same job that everybody else is doing. The second title is a title that is any governmental entity. So your state, your townships, your cities, the county, even the DRC, if you're getting state money, is covered by Title II of the ADA. And so In Title III is other public entities that would be getting any service that might be out there. So hotels, restaurants, businesses, anybody else who might have a small claims action that could be coming up that's from a public place may be a Title III entity. Title IV mostly covers communications and activities of how information is disseminated and making sure that persons who are deaf have access. And Title V is the miscellaneous, so sometimes there's a new provision that gets in there, or there's a piece that didn't quite fit one of the others, and they give us talk about it there. It's nothing that stands out as its own that's in Title V by itself for me to give you a crisp example at the moment. But those are just a general overview of the ADA. The disability awareness and etiquette. What I gave you here is some brief pieces that are on the sheet, and this sheet has, when I was working for the Ann Arbor Center for Independent Living, this sheet we created because it gave some kind of jovial pieces here to kind of get people to smirk at it or say something about what the comment was, and then maybe they'd read what was under it. Because you know how sometimes when people don't have an identity with something, they don't read it at all, or they say, it's not important. So sometimes when people see, hey, talk to me, they're like, what's that about? And then they'll go in and read what it says. We also use these, or the Ann Arbor CIL uses these, with the disability awareness workshops that are done for all fourth graders in the Ann Arbor schools, as an example, and sometimes they're done in other systems as well. But so we use these every time that a situation would come up, and it's basic enough that a fourth grader gets it, and yet it's content enriched enough here that folks who don't know about disabilities learn something usually when they read this. And so on here there are different things like the hey, talk to me. If you're a person who has an interpreter, sometimes people start talking to the interpreter, or they start talking to the 2-year-old, not to the 2-year-old, but to the parent instead of the 2-year-old, or to the adult child instead of the elderly parent, when the person that should be talked to is the person who has the disability, or the person you're trying to find information out. You may get more afterwards from the parent, or you might get more from the daughter or the son later. And sometimes the interpreter may have to help decipher the content that's going back and forth between you. But the interpreter is only going to interpret the actual content that's being said. They're not going to answer the other questions for you. So that's a great example that's on here. Another piece that was shared earlier about the deaf is very important, is that people who are deaf are intelligent, articulate, knowledgeable folks who sometimes aren't given that equal opportunity to communicate or engage because they don't hear things the same way. It doesn't mean they don't know things, but they do have a different language often that they've also learned, and that we are ignorant and that we don't know. Not that people who have deaf as part of their background don't necessarily have. Also, people who have hearing impairments that come with age don't know sign language. So if you say, oh, well, I'll give you a sign language interpreter, that's not going to work if you're not a person who speaks ASL, as an example. Other ones would also be if you don't understand somebody, not to just nod your head and agree with it, but actually ask for that to be clarified. If somebody's using a wheelchair or some other mobility device, that's their device. That's part of their personal space, not coming over and leaning on it and taking over their space. And also, if you want to give assistance, ask first. It's really important. If you are trying to help somebody get through the door, and then because you pull on the door they fall over, or because you pull on the door then now they didn't get to get their exercise, or maybe they wanted to be independent, let individuals be able to state what they may need. Or for example, for myself as a person with a vision impairment, I love having folks help assist me to walk in the dark if I'm with them. But then it's up to me to say, may I please have that guidance and let me take your arm. It's not for you to grab me and pull me or tell me what I should be doing, kind of thing, as examples. There's some others that are on here. Another really important one is for service animals. Service animals are working animals, so we should never go just right up to a service animal and pet them. We also should not call them across the street. If you think about what we say to the fourth graders is, what happens if Sally's walking with her dog and Max is bringing her across the street and you're calling Max to come play with you and there's a Big Mac truck that comes, right? That wouldn't be a good answer, right? So we talk about some of those things. Now, some of those things that we've mentioned may come up in mediation, some may not. We're going to get a little bit more detail on some of these pieces as we go through, but I wanted to just give you just some basic overview of some disability etiquette pieces. There is a ton on disability etiquette that's also available online from various resources. There's a lot of TED Talks. Sheila Young has a great one as an example, and there are many others that are online. What I want to talk about is, what does inclusion mean? Inclusion means that you are in the room, that you are part of the conversation, that you have the same content, information, attention, opportunity to participate that everybody else has. It doesn't mean that, like the example of talking to the interpreter or being pushed out of the room or being told that you can't do something because of your disability. Sometimes there's different accommodations that are harder to accommodate, and you have to be creative with that. For example, somebody could have a service animal and somebody could have extreme allergies, and so then we have to figure out, how do we both integrate in that space? And sometimes we can't both be in the same space at the same time, and we have to figure out how we do that. So as an example, since we all know what caucusing is, it may mean that you may have to do more caucusing in that particular situation as one answer. Or it might mean that we need to do a videotape and have both, like a FaceTime thing where you both can see each other and we're still mediating, and here's another way that all the content is there. For a person who's sight impaired, as an example, it might be having the large print, like I have here for myself today. When I get a mediation case and I'm co-mediating, I often cannot read what is sent over from the court to read because it's too small. And so then I'm trying to enlarge it either on my phone, or the co-mediator is telling me the generic gist of what's in that information so that then we can mediate together. Just as some examples there. How we can do better at what we do here at DRC or anywhere in the community at large is in that intake process. There could be some more information that could be gathered perhaps on the mediation forms. On our mediation forms, I meant to ask you this before we started, do we say, do you need an accommodation to participate in this mediation process? And I don't think we do. I don't recall seeing it there. Is it on there?
Are you asking a question?
Yes,
okay.
Sally or Belinda. Is it on there?
Small claims is a little bit different because
Right.
of how it happens,
Right.
but for other cases that come through the office, we are asking about accommodations.
Okay.
Do you have any needs or accommodations?
Okay.
And that oftentimes is about medications and meals, which you've expressed
Right.
already,
Right.
the ability to do that, and
Right.
it becomes problematic because coming into a courthouse, it's hard to bring in food. So
Right.
we've had to get creative in how to have healthy snacks for the diabetics and
Right.
frequent breaks. So we tell you folks who are mediating, this case may need frequent breaks.
Right.
I don't know if they go into the details of why, but we at least let you know they need frequent breaks.
Okay. Yeah, and so it might be nice to see if the small claims court would add their legal responsibility on their form.
Yeah, I agree.
So I'm just identifying it, not necessarily the next grand march, but definitely something to be thinking of. And then questions on the phone intake, so you're saying that those are asked, which is good. And then, of course, the notes back to the mediator or the discussion back to the mediator, something else that might need to happen regarding that. And then the mediators to prepare. So when the mediators are getting set to go and look at the file and then plan what's going to happen, how they're going to set up the room, where are we going to be. There are different sized spaces that we all have met in when we do the mediations. Some of them are very tiny for even those of us who maybe don't have a mobility impairment. If we have a group that's coming in that space. And so just thinking creatively about how that is. But a very simple one for the physical disabilities is that for a person to sit in a chair and sit at the table, you need at least 27 inches underneath. Okay? You need at least 27 inches underneath the table. These are like that, so they're fine, as an example. Also, being able to come around the space. You need at least 5-foot turning radius to be able to do that. Or 3-foot and 4-foot to be able to back in, back out kind of thing in order to do it. And now, not every person with a disability is a perfect driver of their devices, but that's the legal requirement for how much space you need to have. And there are others that will be part of that, but those are just some basic ones. Also, if you know that you're going to need frequent breaks, figure out where is your break going to be. Where is that person going to be permitted to go? Because when you're in a courthouse, we don't always have full choice about where everything can be all the time. Or where would that snack be taken? Or where would the quiet space be that they could go if it was a person with a disability that needed that kind of space? And being able to know it. And then, if necessary, to be able to have a potential conversation with somebody ahead. So, for example, if you find out that there's somebody that you're going to have in your case who has a hearing impairment, it may be worth first identifying to them that you understand that you know that, and that you're going to try to make sure that you're sitting without your face being blocked with your hands so they can see your lips when you're talking, because that can help. As well, if the sign language interpreter is there, you're not going to be talking to the interpreter, you're going to be talking to the person. But then also that could be something that's introduced at the beginning of the mediation so that somebody knows. Part of that would also then be, if you've met with the person, then you can get that permission in order to share what you can share. Sometimes, again, like Belinda was just sharing, we don't always know all the content because we might not have been told that it's possible to know it, and I cannot. Yes, it is. It's just thicker paper. When you introduce yourselves as mediators, it would, I think, be a great time for all of us to also ask at that point in time, not only do they understand what we're saying, but are there any accommodations that haven't already been disclosed that we should make sure we accommodate in order to make sure that this process goes smoothly for you? So it's adding like another one-liner there. And then if there was this agreed upon disclosure ahead, to then just re-identify that at that point. Throughout the session, of course, is our observance and our checking in with people. We do this anyway, but it's something that really helps for people with disabilities. If you notice that, as an example, a person who might have anxiety, or a person who might have Tourette's, or a person who might have PTSD is getting more agitated in the process, then you might be able to say, I'm wondering if a break might be good for all of us right now. And it's not identifying the person with a disability, it's identifying a solution. Does that make sense?
I have a question.
Yes, please.
Okay, so I'm confused because is this special ed mediation techniques used in mediation, and what are the types of situations? I was assuming that this would be in an educational setting, but I'm hearing small claims. So could that be clarified for me?
Yeah. All types of mediation.
Okay.
All types.
Do you understand what I mean?
No, I don't. You said
Okay,
something about
so in special ed, special education,
Mhm.
is an entity under the WISD, the Washington Intermediate School District, and they also do what they have, a collective meeting with parents of children with special needs. They will have meetings to discuss individualized educational planning. And those can be done as frequently as every 30 days, as by law. But I thought with special ed mediation, that mediators would go to these meetings. Parents often have trouble with an IEPC or a academic meeting of minds. They will have the teacher, social worker, maybe an assistant at these meetings. And so I was thinking, I'm probably wrong here because obviously I am, that the special ed mediation is not specific to educational issues at meetings where mediators would go to help the teachers and the school system to comply with an IEPC. But to work in, and I'm asking you to fill in the blank here, what's small claims then? And
I think what your question is,
right?
Was this topic specifically for special ed mediators?
Obviously, it's not.
It's
No,
not.
it's not.
Right,
Yeah.
and so
Okay.
then,
Yeah,
right,
yeah, that's
and
what I
so
thought.
that's surprise to me.
So we do have several special ed mediators who are here in this room,
Uh-huh.
but they also do small claims.
Okay.
And so
Okay.
we were
Okay.
talking about how in special ed, you know there's a person there with a disability.
Yes.
But in small claims, you
Yes.
might not know it.
And
So-
that's what I'm trying to tease out as well, because will they after the fact, or just come to the mediation meeting and you find out?
Right.
Okay, and so there's
Sometimes.
no way to kind of, when you're gleaning through the cases, say,
so
are you gonna need some visual?
Special ed mediation, I don't want to confuse people who don't do that. It's such a specialized
Right.
area of the center's work that is highly controlled by the Department of Education as well as another third-party entity. So those disabilities are disclosed
Right.
to the third-party entity of the child. We may or may not know nothing about the abilities of the parents who are at the table making these decisions. So
Or the abilities of the other persons in the
The
room.
teachers.
Teachers or the.
So
Principal.
that is not
Right.
disclosed to us. We know the child's diagnosis, we know who's going to be at the meeting. So to Carolyn's point, that question of what other accommodations, that becomes a critical question in that particular case. But I just, those who do these cases, and there have been some recent changes that I'm still trying to understand, got another email today, it's very complicated in terms of programming. Overly
Coordinating,
complicated.
sure. Yeah.
Overly complicated. But to your question, this is about anybody. I think what Carolyn's presenting to us can apply to any case that we touch.
Yes.
And there's some uniqueness about special ed that we have absolutely no control over. So to the point that I know that you spend a lot of time in that space, the special ed space, I have done a lot of advocacy.
Yeah.
I think a lot of this should be shared with those institutions that control special ed.
Okay, and so then my next question would be, administratively, is there some way, in a non-offensive way, to find out in advance when you're going to go into a mediation, whether or not anyone needs, you said on here, visible disabilities or hidden disabilities, if they're going to need any accommodations?
Right.
And Belinda was saying that we do in phone intakes.
Okay.
But in small claims, we don't do phone intakes.
Okay.
Exactly.
Okay.
And if
So
if
like, that's
a
the
person
situation where you're
discloses
confronted
to
with it
you,
and may not recognize it.
Okay. Okay.
So if we know, some court cases, it's pretty visible, especially mental health. That's pretty clear. Somebody's documenting that. But I do believe there are a number of cases that have come through the center where it was never disclosed because a person filed a petition in court and didn't say it. And by the way,
Yeah.
I have this disability, so we never know. Even in phone intake, they may not disclose it. I am too, type 2 diabetic. I have never thought about that. Now, I happen to have a bunch of snacks at my desk, so I do get to do my snack thing because I know I need it, but I have never thought about that in a greater context of my employment, that someone could structurally, now let me eat my peanut butter and crackers, which is my favorite snack, but I just,
Right, well, imagine, here's a piece, what if the person.
I never thought of it as
What
a-
if the person
as a
who is in
disability.
the office next to you, or in your case as a director, you don't should probably share your office, but if they were in the desk next to you, the office next to you was a person with a peanut allergy, so they were chemically sensitive, and they couldn't have the peanuts, but
Right,
you
right.
needed a snack. There would
Right.
need to be a mediation between you guys to figure out how that was going to be handled.
Well, yeah, I think,
Right.
I mean, yeah, I
The
agree with
decision,
you. I just
yeah,
never
right.
thought of
Yeah.
that medical diagnosis being
Right.
part of
Yeah?
a disability, or having, luckily I have not been in a position where I've had to really disclose it, and, I mean, people in the office knows about it, they've been very helpful and supportive, because there are times I really need to eat, but, yeah, just never thought of it that way. So to the extent that people disclose
Yeah,
things,
yeah.
we have information to work with, but again, we're relying on people to disclose it. and I don't know how to.
And people do not, I should have said that at the very beginning. Nobody ever has to disclose their disability. It is up to them to disclose it.
Mhm.
And if we make assumptions about them because we
Right.
think they have a disability, that's not right either.
Right.
So,
right.
yeah. So there's a combination there. The pieces that are just so critically important with that is that continuation of open conversation about it and being open to having an open mind for individuals to be able to feel comfortable enough to share it. Again, sometimes in a special ed mediation, you might be with one case and then you might be with that same case again another time in the future. So you might get that opportunity. Most of the time, small claims, it's one and out. We have a few frequent flyers. We're more than a few frequent flyers. But when that happens, we don't get that opportunity to build that rapport. And so part of that is how quickly can we create that rapport. And some of us in the room are social workers or have worked in different kinds of things like that. And so we are trained on how to create a relationship where we can engage with people and have eye contact, and we know that, and we know what we're supposed to be trying to do. So even though I'm a person with vision impairment, and even though I can't see your eyes, I know that what I need to do to make sure that you know I'm paying attention is when I hear your voice, I look your direction. I can't see your eyes from here. You could be frowning and making silly faces, and I wouldn't know that. But then if I needed to make sure that I wasn't getting information because it wasn't going right, I would have to do something for myself to be different. So I might need to move closer to you. But what if I move closer to you and I cause you to have an anxiety attack? That would not be good either, right? So we just have to be observant and measured in how we look at what we're doing and how we do it. This next piece here is about looking at some scenarios. And so I have some different ones I was going to pull out to talk about, and just here, and at any point in time, I should have said at the beginning, I am visually impaired. I can't see if you're raising a hand usually, so please do as you just had done, and just let me know that you have a question, and I'm happy to try to answer it. So for an example here, a person with a learning disability, they may have difficulty concentrating, and so maybe they might have a request to have a room that isn't overly busy. So to not have a room with all kinds of pictures and things hanging and things like that on the walls. Having a room where they can focus their attention on. I think that it actually applies more to attention deficit disorder, but this particular article that I pulled this from has it as part of learning disability. For a person who's blind or visually impaired, sometimes being able to have the content ahead will make information easier to share. So if, for example, I know Miles just sent out a request for mediation that's coming up about neighbors, and in that mediation piece he gave a little bit of the scenario. So for a person who's visually impaired to know that ahead of time is easier than, as an example, a small claims court, you walk in and you're like, oh, what do we have to do here? And so we try to figure that out. And we try to see how we can do that. For that piece, it might be that both parties then could exchange their information earlier, would make it more of a level playing field. Because if the person who is blind needs to be able to know the content ahead that's from the other side, but the other side doesn't get information, is that then an equal playing field? Probably not. So that would be another way, again, to be able to, even though it's helping the person who's visually impaired, it could help both parties at that point, as an example. Sorry, did you question? I thought I heard something.
That makes sense.
Another piece would be, what is a qualified interpreter and who pays for it? So the person who is deaf, who needs to come to trial, does not, or come to mediation, does not pay for their own interpreter. It is required that the nonprofit organization or the legal entity, which could be a school, it could be an employer, it could be a doctor's office. If you're going to be doing a mediation, you've got to provide it at that point in time. And then we don't talk to the interpreter, we talk to the person, the interpreter will interpret the content. And that qualified interpreter, is a questionable thing. It's complicated because for education, there's different levels that are required. In the state of Michigan, there's different legal requirements for licensure. But sometimes somebody will say, no, my grandma's fine. I can interpret for her. And if grandma says that's okay and grandma is saying that that will work for her, then that could be the qualified interpreter. But we need to make sure that that's what grandma wants, not what the child is saying, right? That is what is needed at that point in time. As an example, a person who may have bipolar disorder might have a manic episode, or may have something with their medications for the timing of when they need to have their content be covered. Maybe it's that they need to really be a person who's going later afternoon versus the morning. Or maybe it's somebody who their medication, they're more alert first thing in the morning. We don't know, but if we've asked for the accommodation, we've given them that opportunity to tell us, then we're giving that opportunity to try to make some of those pieces be there. Somebody, as an example for also going back to blind, is like what we just did this today. We went around and you each said your names, and then mostly I will know who's in the room. Now, will I remember every single person that I know about who spoke is sitting, and I can go back and identify what's happening with that. In this particular case, I also get a cheating mechanism because I know so many of you in the room. So that helps as well. But for somebody who's not sighted, knowing that ahead makes a really big difference. Let's see if I can give you one more example here. I think we have in your handout that you have towards the back of it in Appendix 3.
Is this the guidelines?
The guidelines, yes. You have some scenarios in which the mediation is described as being a problem without the disability etiquette and then with the disability etiquette. So if it's in Section 3, Appendix 3, I think that's where it was. No?
Appendix 3 is the name of it. Here's mediation training.
Hang on 1 second. I find it. Mine's in large print, so where does it start? It's my problem.
Sally, it's near the back of ours.
Okay.
It is near the back, but it's
What's the headline?
It says it's Roman numeral 3 mediator training.
Okay.
Capital A, ADA training content, then small a disability etiquette.
Okay.
yes.
Disability awareness, and then
Oh,
Where are you finding yours? Somebody's finding it differently?
mine doesn't say what, I think if you go back some more pages. Oh, you want disability etiquette, right,
Does it-
Carolyn?
I think if you go to where it says disability etiquette will be good. I don't know if yours has a page number on it, because mine does
doesn't.
not.
Ours does
Appendix,
not.
I thought-
appendix number 3.
I thought it was in Appendix 3.
Yes,
Okay,
yes.
okay, all right, sorry about that. So,
No, it's not
not
appendix
Appendix
3.
3.
it's not Appendix 3?
No.
No, it's the one
It's the
before
page
that.
before that.
Page
that.
5 from the end. Or
Okay.
page
Five from the end.
Page 5 from the end, sorry about that. Okay.
And then it says mediator training and mediator training context. Then it says disability awareness is the first paragraph under that.
Okay.
And it gives, yes, an example of the person who introduces people and
It's in the
points to
middle.
them.
Right.
And points to them.
It's in the middle of that.
Right.
Yep.
Appendix 2 is appendix
And I got to know if we're on the same one.
Yeah.
I should have done
section.
So before appendix.
Yep.
So back here.
Oh, I was looking at something else, but
Director of Attorneys, there's another.
anyway,
And-
let's go through this. If one of you would kindly read one of the scenarios where it was not providing disability etiquette, that would be great. I know there's one on TBI as an example that is there. If you wanted to look at that one, or if you'd like to look at a different one. TBI is a traumatic brain injury. I can read it aloud even. I just do that. It is in your scenarios of your booklet that you have. And an inaccessible case scenario would be a person who has self-identified as having a traumatic brain injury, a TBI, has trouble sequencing, and has poor short-term memory. She is unable to keep track of the proceedings, repeats herself, can't organize her responses, and asks questions that have already been answered. The mediator believes that she is being disruptive, not paying attention, and not participating in good faith. The process breaks down. So here's the same scenario with effective process accommodations. Having been informed that the party has a TBI, the mediator before the session inquires as to the person's needs and limitations in order to make the session accessible. Based on the person's input, the mediator periodically reviews what has been said in the session and works with a flip chart so that the person with TBI can follow and participate in the proceedings. Alternately, if the mediator was not informed before the session, she inquires about the person's needs during a private caucus, even if she is knowledgeable about TBI, as it affects people differently. So even though we know some of the pieces, we never know all the pieces because we're all unique individuals. So as an example, just before we heard Belinda share that she has type 2 diabetes, I have type 1 diabetes. So we both have diabetes, and we both may have food issues, but they might be at different times or different reasons or different causes, or we may have different reactions to what we need in different ways. So you could have a general gist of what that might mean, but it might not be the same. Does that make sense? So it's always asking open-ended kinds of things that could help lead to things. I don't know if, as you look at any of the other scenarios that are there questions that they're raising for you? Are there questions that are coming up for any of you regarding some of the scenarios?
It's very easy to make a mistake.
It's very what?
It's easy to make a
It
mistake.
is easy
as
to make a
mediator.
mistake. It is
Trying
very,
to
very
keep-
easy.
Keep track of all the possible disabilities that have not been revealed.
Yes.
That the person may not, the party participating may not be even aware of.
Right.
Like traumatic brain injury, I know
Right.
a lot of people who
Right.
deny it.
Right.
And-
They may deny it, and if you think about it, every single person at some point in time has bumped their head, right? Haven't we all bumped our heads? Now, that doesn't mean that condition, in your case, impacted you significantly enough to alter what you're doing. In my case, I don't have great balance, and sometimes I can't find the word that I want to say. Those are the things that impact me with my previous brain injury, which was before this accident. And I don't know yet, except for the vertigo, how this one's impacting me yet. But both of those were pretty significant. They weren't. I don't have a severe brain injury, but they were significant enough to alter how I did things when it happened. I don't wear high heels anymore because I don't have good balance. So there's no point in trying to create a problem for myself is with my accommodation that I made for me. But for some folks, they have much more significance. Some folks who have brain injury have great difficulty speaking. Some folks who have brain injury have inability to be mobile. Some folks who have brain injury have difficulty breathing. There can be different kinds of things. We as mediators and we as the public can't know the answer to every single one of those things. But we can all be tolerant. And we can all be open to learning about it from that person. And so when we make a mistake, it's okay to make the mistake. We're all human. And what we do when we do that is say, oh, I'm sorry, how would you like me to accommodate that need better? Or what could I do differently? Or how could I be helpful? You know, there's just some different ways that you could say that at different times. And none of us are perfect. We're not perfect. Those of us who work in this field are not perfect.
Carolyn, I'm wondering too, you
Yeah.
talked about the use of caucus, using caucus
Mhm.
maybe more frequently, that might be helpful.
Mhm.
I'm also, feeling a little bit cautious around the content of that caucus. Like, I don't want us to believe that we have to have this level of expertise around this TBI or whatever the disability is to try to insert some pieces that may not be there. So
Right.
not to abbreviate the mediation too quickly or at all, but also reminding people that if they need another resource in the room, a support person, an advocate, or whatever
Right.
kind
Yes.
of person in the room, and we can schedule a different session if that makes sense. Or maybe they are on information overload,
Right.
and they just need to go home and
Right.
process it and talk it out with somebody else, or and then come back and,
Absolutely.
because well, from an ethical perspective, we don't want people signing an agreement if they're not feeling competent and prepared and ready to sign that
Right.
agreement.
Right. And you had another speaker, what, Suzanne? I can't
Susan
remember.
Butterworth,
Susan,
maybe?
yes. Susan, who did some on capacity,
Oh, yeah.
right?
You
And
know, Linda, from my experience with Sally managing our small claims docket, when she's directing people to a mediation room, she will often determine whether or not the people who are being asked to come into the room are a party to the suit, and limiting the participation. And I'm not quite sure if that's in conflict with the idea of first determining whether that person is necessary. And I just question what
I
you're
was thinking of
saying.
the same thing. Sometimes the support person will tell people only the people on the docket can come in.
Yeah.
And sometimes they'll say specifically, I need to be with my father because he doesn't speak English very well. And so then I try to accommodate that and explain to the mediators, you're supposed to get the permission of the other person. If it's the defendant who has the support person, get the permission of the plaintiff. But I think we probably need to rethink that. Here is a person with disabilities that may need that support person there a little more carefully, and that's...
right. And I think that again, it's that
Yeah.
piece of identifying it to say that that's what is needed. I mean, the person, if as an example, there was a person who was using a chair and they had a person who came with them to be their PA for their disability needs versus their support person or cheerleader for the event, but the other party doesn't have a support person or cheerleader, that's different. That PA is not considered to be another person.
PA is not public advocate.
No, PA is personal assistant or PCA, personal care assistant. And that would be different.
Is that a technical term, personal care? Is that defined someplace, personal care assistant?
Yes, people hire a personal assistant or a personal care assistant to help manage some of their disability needs.
So that might need to be explained to either the plaintiff or the defendant,
Right.
why that person is in the room.
Right.
So something...
Again, getting permission from the person beforehand, and that person then, if they're the person there to assist with the disability needs, they shouldn't be in the conversation about
What's being settled.
unless that person is the party that they're assisting is asking them a question for clarification so that they can understand better to be functioning in that session. But not that they shouldn't be let's just say it's Mary and Sue, and Mary's the person who has disability and Sue's the assistant. Sue doesn't start to then talk to Tom, the person who's in the case, without it being what Mary's asking to be said. Does that make sense? It has to still be for that person. Is that clear?
Yeah.
Just like the interpreter who would be in the room, you wouldn't ask the other party, do I have permission to have the interpreter in the room? You would announce to the other party, there's going to be an interpreter in the room because this will allow the other party in the case to understand what's going on.
Unfortunately, the parties are coming to mediation
I know.
often thinking in terms of the context of a trial.
Mhm.
And there
I
they
know
can
that.
have witnesses, and they can have other parties who can be sworn in to be an active part of the hearing or the trial.
Mhm.
We try to avoid that in mediation by keeping it as
I know.
non-trial-like as we can.
I know.
And keeping it as simple as we can.
Right.
Oftentimes, simplicity isn't the answer to a problem, but it's an effort we make.
Right. And it works often, so that's why we do it, right? But at the same time, if it is an area that's going to be a barrier to being accomplished, what we're trying to do, then we need to be open to the other ideas. So that's the piece of it. Looking at how do we structurally make those adaptations as we go.
I was thinking when you were talking about accommodations for a brain injury too, that I think sometimes one person will talk and explain the whole thing. And if another person can only really hear one thing at a time, it might be important to reframe, to interrupt. If you feel that someone's not following, to go step by step and kind of break up the pieces of it in individual slices.
Yes.
So,
And, obviously, we also all know that when we break things down for all of us, sometimes it makes it simpler for everyone.
That's true.
I was thinking about one of the things sometimes that, as an example for a person with Tourette's, sometimes the content that is shared is not appropriate for the content of what's going on, but it's involuntary, but it's coming up and it's what they've said. It still might go on your list of the board, but you know how when we then narrow down to where we're working, then you'd be able to say, this sounded like it was maybe not related to the case. Should this come back off the board? That kind of thing. So you're still recognizing that that's what their contribution was at that point, but being able to then redirect us back to where we're going. That's what we do anyway in mediation, right? So that is there. Are there other kinds of questions or concerns that anybody has?
I would.
Oh, sorry.
I am wondering, I'm tooling around in my head, what's the question that you ask, you ask at the beginning to get at these issues? Are there any particular needs that we need to accommodate? Or, is it something like that? Sort of
Do
a
either-
generic?
Yep. Do either of the parties have any accommodations that would help make,
Need.
any need for accommodations that would help make the interactions that we're going to have today better or more effective?
Spoken of in terms of needs.
Do you think it would ever be appropriate, like if you feel that the advocate, and I had one case where it was a very old man who was not fully engaged, but his children were advocating for him and being his spokesman. But I got the idea that they were kind of at odds. Would it ever be appropriate to have him removed from the room, even have the advocate and just caucus with the person, but he was clearly not all there.
Right.
So that the advocate was not unbiased, to a very strong degree.
Right.
Any
So-
insight on how to handle that?
Yeah, so the legal piece of that is if the advocate is the guardian or not, right? Who has the power of attorney? Does he have his own power of attorney? Is he his own guardian? And if he is, then he gets to decide.
Unfortunately, in civil matters, mental capacity is not an affirmative defense.
Yeah.
So that people with limitations can be a party to a civil suit
Yes.
and not have the advantage of having that mental capacity. So there's some inequity in civil matters.
There could be, but if the person, I'm sorry?
I said that to me is for all court cases.
Yeah. I mean, there is, the pieces there that are important is that you have tried to offer what you can, and you've tried to make sure that the person is feeling that they want to proceed. What we have to do is try to be that non-biased person, right? And so if this person is not presenting in a way that you feel is appropriate, one of the things that we can also do as mediators is say, we need to stop this case. I can't proceed with this case and feel like I'm ethically able to proceed. And then Sally could say, okay, I'm going to go in there. And then Sally could say, no, we can't proceed with this. Or it could be that it needs to be rescheduled for a different day. Or maybe we find out at that point that, yeah, in fact, they didn't take their meds that day. And that's why things aren't functioning as well for them as that maybe they normally would have been for them. or maybe there's a better time of the day to do what needs to be done. We don't know until we ask the questions. And there are times, though, when individuals have different answers about how they'd like it, or there could be like the two advocates, two different, you could have one adult with two children, and the two children have very different views about how it should be handled, and then now it's getting into a match between this family and not the two people who are supposed to be interacting. And that can be complicated as well. And then the simplicity one. One in the room, and then it's who's going to be the one, right? So then we have a different problem, but yes. Yeah, so those are some of those pieces.
Let's have a little mediation session with the two of you.
Yes. Can we have a
Just
private
invite the
one?
parties who are supposed to be there.
Right, exactly. The part, well, you were out of the room when you solved the case.
Right.
Because you took the other advocates out. Are there other questions that are right at the top of people's minds or concerns?
I
It's
have
not,
to take
oh, go ahead, Tom.
one of the most interesting mediations I had was involving a couple who had divorced, but their child was deaf, and he was born deaf. And the mother wanted the child to have a cochlear implant, and the father would not agree to it.
Mm-hmm.
Father was an engineer, by the way, and said it's not perfected enough yet. So, actually, this was referred to me by the judge. He said, I can't decide this. You see if you can get him to decide. Well, it got really complicated because I think the reason the couple got divorced is because of the child's deafness, that the father blamed the mother for producing a child who was deaf. So we called in, we said that I brought in some experts to help us with this. One of the most fascinating parts about it was I brought in an expert from the deaf community. And she said, he has a right to be deaf. And there was kind of a movement in the deaf community. No, don't try to, it's like if you have blue eyes and I really want a child with brown eyes, they have a right to be that way. So don't try to correct it. But they can get disabilities can get really incredibly complicated.
They can.
Especially when one party's trying to correct the other. Another one, I don't run into it here, but I ran into it a lot down in Southern Ohio, was a person who cannot read and has never, could be an elderly person or a person who's of young age, but never learned to read and refused to acknowledge that.
Yes.
And so when you're handing them the consent form,
Right.
and then they look at it and they put down their name, but then I get the feeling, I don't think they can read that. So I had to take them aside and up and talk to them about that. He would not disclose that.
Many will not disclose that. I mean, it's not disability per se related. Sometimes it can be, but
this was
other.
not a disability that he just never went to school.
Yeah. We have college athletes who don't read. I mean, there are folks that didn't get the supports that maybe were needed in some way at some point in time. Some folks have difficulty because of other learning disabilities to be able to read, but there are, or other cognitive functioning to be able to read. But there are different pieces. But yes, while he may or may not have said anything to you, and he didn't want to tell you, he probably at some level appreciated that you were making sure he understood whatever was on the paper he was signing. If he did.
He ended up being embarrassed. I could read it to him, but then I as the mediator, that was an awkward position for me to be in.
Right.
Well, that's why I'm glad we have to, in our sessions, we must read that consent out loud, everything on it. Because I think that takes care of it for whatever the issue about reading is, or, they're going to sign it.
And the same with the agreement.
Mhm.
Yeah.
read
Yeah.
the agreement.
Yeah.
Several times.
Yeah.
Each correction.
Each version. Yeah.
Not for
Each
the
edit.
disability, but the disagreement.
Yeah, the chicken scratch is a handicap.
That's right, can't-
I'm wondering, I like the question of, how do we present this in the beginning of the session? What if something has not been expressed by one of the parties and it becomes obvious to us that there's some kind of disability interfering with the progress?
Mhm.
If we say, well, let's caucus, and would it be appropriate to then suggest to a party, it seems to me there's a problem here, or what else could I do to help you progress through this?
Right.
I guess that would be a better way.
right.
But would they?
You could say, am I correct? It feels to me like there's something that's limiting the progress. Am I missing something? Meaning me,
Yeah.
the mediator. Am I missing something?
That's
So
good.
make it your
Then make it
problem.
my problem. And
Yeah,
then they can say,
yeah.
no, it's not you. I really do have a hard time processing information, or I just don't understand why we're here for this, or whatever. And then you have someplace else that you could go with it at that point if they give you a response.
I'm wondering if there's some biases or prejudices from the other party that might surface within the mediation that we didn't
Yeah.
think about before.
Right.
And that might, maybe
Yeah.
they had somebody in their family with selective hearing, and this person who has the hearing deficit is just stirring up all that anger from the other one.
Right, right. Yeah, that does happen. And so there are pieces that will come out. I mean, one of the cases that I had helped to mediate in, the couple was divorced, but clear as day, they were not done. I mean, there was stuff going on. In fact, the co-mediators that I was with in that particular one said, maybe you guys want to go for coffee after, but can we get back to what we're doing here? Because I was just like, I'm usually pretty good at some of these things, so I thought, I'm getting stuck myself. And she said, I was like, oh, good, okay, we're going to get over this hump. So there can be, as you know, every case is different, every person is different, so there's pieces that are there.
In small claims, oftentimes the inequity of the parties would be a matter of a defendant being the first-time party to the process, and the plaintiff being a professional lender or business has many advantages of awareness how the procedure works. So
Right.
you have to take your time to make sure that the defendant is kind of brought up to speed,
Yes.
because they have
Right.
a handicap disability at that point. The disability is lack of experience in that process.
Right, yeah.
That's
Yeah.
interesting.
I could see that would be another way of looking at that, but also, as an example, sometimes it's the lenders, and we have folks with disabilities who maybe didn't understand what they signed with the lender in the first place, because maybe what happened is the lender didn't explain it clearly.
Well, there's no provision in the lending business for that type of disclosure. Sign here.
I understand. Maybe we need to create one. I don't know. Anyway, but you get where I'm going with that. That there are different times and different places in which content is not clear to everyone, and so when we try to make it clear to everyone up front, that helps the process, and that helps people with disabilities. And when we make things accessible for people with disabilities, it usually benefits everybody in the space. So, for example, if somebody is having a hard time and needing that break, and people are seeing that person get agitated, maybe they don't like the fact that the case is going to go on longer, but if then it can come back together and it's more peaceful and easier to get through the process, the other party is going to be appreciative of that also. They don't want to be in an agitated situation either, typically. I mean, they may not be in agreement, but they may not really want to be having that. So that's just another process there. Are there other questions or other concerns? And then I can give you a little bit of a conclusion. So I just wanted to let you know that, again, one of the pieces is that there isn't a true requirement in the DRC or in other places to have full disability awareness training, but there are opportunities in our community to get that training. I myself am back here often, not every day, not every week, but frequently, and I also have a side consultation business that I'm doing. And then the Center for Independent Living is down the road. Trainings could be potentially asked for or provided by them. Their contact information is on the bottom of the disability etiquette sheet that you have and on here. That there are many resource links. There are several that I have put here. You have a few of them that you're going home with by having the disability etiquette page and by having the guidelines packet. There is more that's out there. Often, though, when you look for mediation and disability, what you're going to see is mediation and the ADA, and that's a little bit different. The ADA itself would be if there was a complaint about a business or a space that was about how the ADA was being enacted. So here in Ann Arbor, as was being shared earlier, that there was we fought this. We ended up having to get to a point where there was a consent decree to make sure that these curb ramps are going to be put in properly, and now they're improper. They are there, but that didn't happen in a mediation. It happened in a more formalized court process. But there is a mediation process to also deal with those kinds of things with cities and with businesses and hospitals and schools and all kinds of things as well. And you were hearing a bit from one of the participants earlier about special education pieces and having mediation. So that's an example of that formalized mediation. And if any other questions should come up that we did not cover, I would be happy to have you email or call me. I'm happy to try to answer anything that I can. And I really thank you all for your attention today. And I hope that this information will help make your next mediation case a bit easier.
So is it possible for people to contact you directly? Is that all right? And if
Yes.
so, would you like to share your email address?
It's on here.
I put the email and the phone number on the form. I guess because you're filming it. So my public email is cgrawi, cgrawi @gmail.com, and my cell phone is 734-417-7732. And, like everybody else, at times things are busy, but as much as I can, I will try to answer anything that I can.
Thank you. That was really helpful.